Welcome. Well, thank you for stopping by my channel again today. My name is John Mazzara with Remax Results, and I have a special guest today that's going to bring a lot of excellent information to us. His name is David Salter. He has his own law firm, and he's in Minnesota, over in the Roseville area, but he works, of course, the entire state. And he's available in person or via Zoom like we're doing now. So I'm going to be quiet for a moment and let David introduce himself and his practice. David, tell us a little bit about yourself.
Well, first, John, thanks for having me on your program today. I'm glad to be able to hopefully instill some knowledge for your viewers. My name is David Salter, and I'm an estate planning attorney, practice in the Roseville, Minnesota area. But as John said, I do have clients throughout the state of Minnesota. I've been practicing for almost 30 years, exclusively in the area of estate planning, so preparing wills for clients and trusts. And I've been practicing long enough where I also do estate administration for people. That's normally for my existing clients, it's trust administration. As long as we have their trusts fully funded, we're not going to have a probate. But if a probate is required, I will also, open probates for clients too if they're needed. A lot of times my probate cases are from referrals, because hopefully if I'm doing my job correctly and my clients have a revocable living trust, we're not going to have a probate when someone passes away.
Excellent. Well, very good. Well, with regards to like real estate and in the direct ownership or indirect ownership or what are you seeing today with regards to maybe some mistakes or things that people should consider with regards to the real estate?
Well, John, when we're in the estate planning area, everything really sort of comes down to how people own their assets. And when we're dealing with real estate, sometimes problems can arise when individual is leaving, let's say a cabin up north.
Mm-hmm.
If parents leave a cabin to, let's say, 4 children equally, what will happen is those 4 kids will inherit that cabin, and the type of ownership that they'll inherit it with is called tenants in common. And what that means is that each one of the kids will own 100% of 1/4 of that cabin. Well, when that happens, there can be some issues that can pop up. A lot of times there's maybe one of the kids is living out of state, 3 of the kids are in state. There's certain kids that want to use the cabin more, certain kids that don't use it as much, but they've all got that equal ownership, so they all have equal rights to go up and use that cabin. And that sometimes can cause conflicts in the family. Another issue with that type of ownership is just it's fractured right away when you have the 4 kids owning the cabin. What can happen is if you have 2 of the kids that are married, they actually own 100% of a quarter. So their 100% of a quarter, those kids can put their spouse on as a joint tenant. So then you can have a quarter owned by joint tenants. Surviving, the one spouse could pass away, not the child spouse, and then you might have a totally unintended owner on that quarter. So that's an issue that we see quite a bit, especially in cabin ownership here in Minnesota.
That's really interesting. And I just imagine if they got remarried and they didn't like that person they got remarried to, now they've got a whole nother family or individual using their cabin that they really don't like.
Yeah, it can happen. It happens more than you think.
Wow.
And then just popped into my head, another issue with that type of ownership is that any of those owners, they can start a legal proceeding that's called an action to partition. And what that means is they have the right to just file paperwork with the court and say, hey, I want out of this cabin, and there's really no defense to an action to partition. And if it's a parcel of real estate, like let's say 40 acres of agricultural land, the judge might say, oh, let's just split that up. It's easy enough to say everyone's going to have a quarter of the quarter. But in a cabin situation, what may happen is court could say, well, you've got to sell that cabin and split up the proceeds equally. So that's, another issue that can pop up with that type of tenant in common ownership with multiple children owning a cabin.
What if one of the kids got sued? Let's say they were in a car accident. Can that be the forced sale there as well?
Well, that's a very good point, John. So since the child only owns a quarter, they would only be able to, the creditor would only be able to go after that one quarter that's on 100% by that child. But if that creditor took possession of that interest, then that creditor could go and file the action to partition to get the proceeds of the sale to satisfy a judgment, if there was a judgment.
Okay. Well, is there a solution?
Well, a couple of ways we can, address that. One of them would be just to do what's called a TIC agreement, a tenant in common agreement. All of the children, after the fact, could get together and set up basically a contract saying, these are the rules we're going to set up to deal with how we're going to use the cabin. It could have terms in there that say we're waiving our right to do an action to partition. And the TIC agreements do work. The problem with that is that once the kids inherit a cabin like that, the horse is kind of out of the barn, John. So the kids have to be in agreement to do that, which might not occur. Another solution, and this is a solution that I like better, and this does require mom and dad to sort of think ahead and create an entity within their own, mom and dad's own estate plan to take care of the cabin after they're both gone. So what we can do there is we can set up what's called, I just call it a cabin trust. Sometimes clients, if they have a cabin that actually, has a name, they'll call it, the North Pine Cabin Trust. But with that, within the parents' estate plan, we can have the cabin trust terms be part of that estate plan so that when mom and dad are both deceased, the kids aren't inheriting this cabin directly as tenants in common, a quarter, 4 quarters as we were using as our example before, but the cabin would actually go into an irrevocable cabin trust for the benefit of those 4 kids. And those 4 kids would be the beneficiaries and the trustees on that cabin trust. And since we're talking about trusts here, let's just back up one moment and do a little trust 101. So when we're talking about trusts, we need to understand sort of the 3 positions that a trust document has in it. So every trust instrument has 3 positions in it. There's the grantor, that's the person that creates the trust. You also see the word settlor, trustor, trust maker. Whenever you hear any words like that, that's the person that creates the trust. The second position in a trust is the trustee. That's the person that manages the assets that are held in the trust, and they manage those assets for the benefit of the third position in a trust instrument, and that's the beneficiary. So every trust instrument, every trust document has a grantor, a trustee, and a beneficiary. And when one individual occupies all 3 of those positions in a trust, that's what makes it a revocable living trust. Probably a lot of people listening right now probably have a revocable living trust. So grantor, grantor, trustee, beneficiary, one person occupying all 3 of those spots, that's a revocable living trust. Okay, so that's important to understand. So and the example that I'm talking about right here is that if mom and dad had revocable living trusts, within that revocable living trust documents, that is where they would put the terms of the cabin trust. And the terms of the cabin trust wouldn't kick in until both mom and dad were deceased. And once mom and dad are both deceased, that cabin trust is created. Mom and dad cannot be a beneficiary or a trustee anymore because they're gone. They would still be considered the grantor of that cabin trust because it was created within their revocable living trust. But at that point, the cabin trust is an irrevocable trust because they don't occupy all three of those positions, and the kids would be the trustees and the beneficiaries. So what kind of terms do we have in a cabin trust? Well, a lot of times we have terms of usage. This is, each family unit of those 4 units, they're going to be able to, one person 1 year will have Memorial Day, the next year they'll have Labor Day, and then maybe, the 4th of July, things like that. There will be terms in the trust about, if one of the individuals, family unit doesn't want to participate anymore, terms about how they get bought out. Sometimes there's a discount for them being bought out. So in a way, it's almost, you can view it as maybe sort of a family timeshare where there's rules and regulations so that we'll hopefully avoid the conflicts that can occur if they had inherited that cabin that original way we talked about as tenants in common.
If that happens, does that eventually have a finite life to it, or can there be a provision in there that says,
well, there's you can't have a trust run forever in Minnesota. There's the rule against perpetuities, but it can run for a pretty long time. And the whole reason you do a cabin trust is, it's the family cabin. You want to have the kids be able to enjoy it, and then even the grandkids. So that's why we sort of talk about in a cabin trust about family units, because that family unit is going to grow as there's grandkids.
mm-hmm. From a creditor standpoint, are there, if you have the entitlement, I don't want to use the word entitlement, but if you're a beneficiary of the of your unit, is that subjected to creditors, and then can they somehow breach that trust or bust it or anything like that?
It's an irrevocable trust once it's set up as the cabin trust. So if it's administered properly, the cabin trust should offer creditor protection.
Okay. All right, cool. Well, very good. So for somebody contemplating that cabin situation, that would be something they probably haven't heard of and should sit down and visit with.
Yeah, the cabin trusts have been pretty prominent in Minnesota for going on. It was probably 2008, 2009. They really started getting popular. So
was there a new law change at that point, or people just
no, it's just I just think people started thinking about it more. So
okay. What about like transfer on death? People sometimes are doing that, and then I had a situation on a listing where that came up, and then it had to be undone. And there were, because the dad actually ended up selling the house while he was alive, so it never did transfer on death, and so and then he was able to potentially take his exemption amount. Anyway, it was complicated, and I left it between the attorney and the accountant to figure it out. I sold the home and let the other two parties figure the liability and what was associated with it. But there were some things that came up. Are you familiar with transfer on death and risks to it?
So it's to me, the transfer on death deed in Minnesota is pretty new, but it's probably been around for at least 10 years, if not longer. So basically, what transfer on death deed is, in effect, you're putting a beneficiary designation on real estate.
Mm-hmm.
And so even if I own my house in my name alone, let's say I'm not married, before we could do transfer on death deeds, if I own my house in my name alone and I passed away, there would have to be a probate to move that house down to my, whoever my beneficiaries, whoever I wanted to have receive it. So basically, with the transfer on death deed, we can do a special deed that says, when I'm gone, me grantor gone, my grantee beneficiary is gonna be, X, Y, and Z. And those individuals will receive that piece of real estate without having to go to probate when I pass away, as long as that transfer and debt deed has been recorded at the county where the real estate's located prior to me passing away. So I'm kind of surprised that John, that there was problems with the sale with the transfer and debt deed being on record, because the transfer and debt deed doesn't transfer title until the grantor passes away. So normally an individual should be able to sell that house, even if there's a transfer and debt deed on file, without that beneficiary having any sort of, say in the sale.
Yeah, there was something about tax liability that was associated with it. If the beneficiary sold it versus if he sold it, then it ended up being that he deeded out. But it was something that together they had to get together and explore in some detail. But ultimately, he was the one that deeded out the dad. So
Well, that sort of segues into another question people sometimes have about, real estate. People will, let's just use the cabin example again. People will say, well, should I just, give my cabin to my kids right now? And one of the drawbacks of doing that is that when you gift something to someone, an asset to someone during their lifetime, they get what's called a carryover basis for income tax purposes.
Mhm.
So let's say that, mom and dad bought this cabin for $50,000 40 years ago, and now it's literally worth, 800,000. I mean, and that happens.
Mhm.
And if mom and dad gift that cabin, let's say to two kids outright, while mom and dad are still alive, those kids are going to take that cabin and have a $50,000 basis. Maybe it would be higher with adjusted basis if they, improved the cabin. But I mean, it's going to be a really low basis. And if the kids had just inherited that cabin through a will or a transfer and debt deed, they would have gotten a step up in basis to the grantor's date of death.
Mhm.
So if they turned around and sold it for $800,000, and that was the value of the cabin at the date of death, they wouldn't be reporting any capital gains. If they had gifted to them, and let's say the basis was 100,000, they'd have $700,000 of gain to report. So
Mhm.
the general rule is it's always better to inherit an asset than have it gifted to you during lifetime.
Sure. Yep. Interesting. What other things are you running into with regards to people in their estate planning and real estate mistakes that had they visited you, they wouldn't have made?
Well, I don't know if they're necessarily mistakes that people make, but it's just it's sort of the whole concept of in your estate plan, you want to plan for all the bumps or all the potential problems down the road. So if somebody has, a revocable living trust, and they're selling their house and they're buying a new house, it's nice to ask the question, well, do you have a trust? Do you want to take title in the name of the trust? If we're in Minnesota and we have a separate revocable living trust for each spouse, which spouse's trust should this, the house be titled into? So those are the kind of questions that I think it's nice for real estate professionals to ask to people when they're, purchasing a house or any piece of real estate. And the reason that is because if you have an individual that's, has a larger estate, in Minnesota, we have a $3 million unified credit to estate tax, meaning that each individual in Minnesota can pass up to $3 million to someone other than their spouse before they have to pay any estate tax. So in Minnesota, a married couple with basic estate tax planning can shelter $6 million. So the idea there is that we want to have assets in each spouse's revocable living trust. So that's why the question of whose trust should this house or this cabin go into is important, because if they take title as joint tenants and then unexpectedly the one spouse passes away, with the joint tenancy type of ownership, the entire value of that estate is going to go into the survivor, and that might not be really where we want to have the value of that real estate. We might have wanted to have it in the other spouse's side in their trust. So that's why I think it's important to sort of, be aware of what the, the client's, estate planning situation is when they're purchasing real estate.
Absolutely. Good point. Very good point. Other things that you're seeing on from a deed perspective, like, one to buy, two to sell, and maybe some reasons why people would, like you just mentioned, to equalize the estate and to take advantage of the credits, and any other things that people sometimes miss that had they thought it through that might be valuable?
Well, I think just this isn't really a how to take title. It's more of the disability situation, and just as part of your whole estate plan, the having a power of attorney. Because, and I've heard this recently from a real estate person I know, if you have a client who's purchasing a piece of real estate and they've signed the purchase agreement and they become disabled and they don't have a power of attorney to their spouse or someone else who can take over and, sign the documents at closing, I mean, that can really mess up a real estate closing, because you might have to go to court and have a guardianship and a conservatorship proceeding to, get someone appointed to have the power to sign on behalf of that disabled person. So that's another part of a good estate plan is having a power of attorney, so that someone can take over as an agent and make financial decisions if the principal person, let's just say it's the spouse that gets disabled, if that person gets disabled, making sure there's someone that can, sign documents for them.
Right. Right. That's a great point too. Yeah, there's so much to it. And I know sometimes people try to do it on their own. And I know they don't take into all those situations and considerations when they do it, because they're not an attorney. So if somebody wanted to work with you and come in and see you, what would be that process?
Well, anyone can just contact us. Our phone number is 651-641-0001. And you can actually text that phone number now. We have a system now where we get text on that phone number. Our website is salterlawllc.com, and there's a spot there you can click on to ask for an appointment. And then you can email me at david@salterlawllc.com.
Okay.
And normally my first hour consultation for an estate planning situation is it's a complimentary 1 hour, be a little more than an hour too, consultation. And normally what I do, if someone's going to come in, I send them a personal information form just so I can have some basic information. Are you married? How many kids do you have? Rough estate size, no detailed financial information, just rough numbers. So we can sort of, look at what their situation is. And I normally have the people bring in any existing estate planning documents they have. So we can sort of look and say, okay, this is how you own your assets. This is what you have now. This is what the situation is going to be. And then sort of look if there's anything we can do to help them out. A lot of times people will come in and I'll review their documents and I'll say, that looks great. You're set. Don't have anything to worry about.
Okay, nice. So second opinion, peace of mind, and if you can improve it, great. And
Yep.
if not, no harm, no foul. You got a new friend.
Yep.
Okay.
And my approach is educational. When we do workshops, community education, we want to educate people about the importance of estate planning, literally starting when someone is 18 years old. You got a new college graduate, grandson, daughter, whoever. When they turn 18, your mom and dad are no longer the legal guardian. Those 18-year-olds are adults. So they need a statutory short form power of attorney at least, and a healthcare directive. So that if something does happen to them, and we learned during COVID, granted, it was normally the older crowd that was having more trouble with COVID, but there were younger people too, told us that, when you're 18, you need someone to make decisions for you if you can't.
Mm-hmm. Absolutely. Great point. I know a lot of people miss that. They don't think they're going to kids are going to predecease them or have issues. And then,
And it's it's hard to do because an 18-year-old, a 23-year-old, they're going to live forever. So
right.
It's not going to be in their mind that, hey, something might happen to me. So I think it does sort of have to come from mom and dad or someone else to sort of, get the ball rolling on it.
Totally.
So a lot of times what I'll do now with clients, I'll say, well, it's part of your plan. Let's do, healthcare directives and statutory short form powers of attorney for your, young adult kids. And, instead of $100, $200 for a graduation from high school, say, well, everyone else gave you cash. We're gonna give you these 2 legal documents that you
Going to
need.
give you some tools, right?
Yeah.
Do documents typically expire? I mean, like if somebody had done a will or a trust or something, do they last forever or do they need to be?
They don't expire, and that's why you sort of have to keep an eye on your life's journey and say, hey, it's time to go in and get our documents reviewed again. Because let's say that you get married, you're 27 years old, and you have a simple will, says, when I go, it goes to my spouse, and then when we have kids, it goes to the kids. Well, that's why, 20 years later, you haven't updated it. You've had a successful career. You've got a lot of life insurance. You could be in Minnesota state tax territory. And at that point, you're going to want a lot more complicated plan to utilize your $3 million unified credit. So they don't expire really. And that's why it's important to keep an eye on it and try to keep them updated on a somewhat regular basis.
Sure. Okay, well, that sounds wonderful. Anything else you would like to share today, David, before we wrap it up with regards to estate planning?
Just my general philosophy again of that, life is a journey, and estate planning is part of that life's journey. And estate planning touches on lots of different spots in your life, buying a piece of real estate, starting a new job, making sure you have your beneficiaries set up correctly on your 401k. Estate's growing. Do we need to, worry about Minnesota state tax? I didn't mention this, but this is important too. You've always got to ask clients, are you going to be inheriting any assets from your parents? And how is your parents' estate plan set up? Is it going to you directly and going to just become part of your own estate? Or do they have an estate plan set up where it's going to be sheltered for your benefit? So it's just life's a journey, and you've got to look at all along the way to make sure your estate plan is working the way it's just, intended to work.
I think that's some great advice. That's wonderful. And there is a big, what was it, $20 trillion or something is going to transfer intergenerationally over like the next 20 years. And
oh yeah, it's a huge number. Yeah.
Yeah. So the need is there and proper planning is there, or people are going to make mistakes, and you'd be one of the best investments they ever made to plan for that so that they can have it done correctly, because people only know what they know and they don't know a lot. So that's why they need people like you to help guide them through that.
Yep.
Well, that's wonderful.
Okay. Well, John, thanks for having me on, and have a good weekend.
You as well. David's information will be down below the video. Feel free to reach out to him. I endorse him. I think he's a very nice man, he and his wife, and they'll do a great job for you. David, thank
Okay,
you.
thank you. Bye-bye.